Okay, welcome back. Away we go. Our first panel today is on the SEC's focus on cybersecurity, and we have the perfect moderator for this panel. So our moderator is John Stark, and John's been working in the cybersecurity area for most of his career, starting with 11 years as founder and chief of the SEC's Office of Internet Enforcement, then for 5 years at Strauss Friedberg in DC as the office head there, and then 20 years as an adjunct professor at Georgetown and Duke Law Schools teaching cyber law. And of course, now as the president, CEO, and everything else of John Reed Stark Consulting.
A janitor. You forgot.
Whatever there is. John has written hundreds, maybe thousands by now, of articles on cyber law and ransomware. He has become a world-class cyber expert. John, welcome.
Thanks, Bruce. Very excited for this panel.
Yeah, it should be a terrific panel. Let me next introduce Jack Bennett, a managing director in the cyber risk practice of Kroll. Jack has over 25 years of experience, including many years leading the FBI's field divisions in both the LA and San Francisco offices. With the FBI, his leadership responsibilities included threat mitigation, cyber, and much more. Jack, we're really fortunate to have you with us today. Can't wait to hear your insights.
Pleasure to be here, sir.
Susan Resley is our next panelist. I want to introduce. She leads the SEC enforcement practice at Morgan Lewis. And she also came up as an SEC enforcement staffer right out of law school, if I have that right. Today, Susan's clients range from boards of directors and audit committees during investigations to public companies, C-suite executives during litigation and class actions. It's no surprise that Susan was recently named one of the top women lawyers in California by the Daily Journal. Susan, welcome. It's always great to see you.
Thank you. Good to be here.
Next, let me introduce Brent Wilner. He is a member of the SEC's cyber unit, which continues to just rack up victory after victory. Brent is also a former deputy AG in California. Really great to have a senior member of the cyber unit on this panel to provide kind of a frontline view of the field. So welcome, Brent, and welcome to the whole panel. John, let me turn it over to you.
Thanks, Bruce. And thanks, everyone, for being here for this West Coast conference. We got people from everywhere. Got a great panel. Let's get started. So there is a tremendous amount going on in cyber right now, right at this minute. Ransomware has expanded dramatically. You now have ransomware as a service, which is sort of a subscription-based platform and toolkit. So these gangs have expanded their operations significantly, including the recent pipeline attack that's impacting, especially, I'm the only one I think on this panel in the Northeast, where there are gas lines like back when during the inflation of the 70s, which I remember when I was just a little kid. And the impact of these ransomware attacks is incredible. The ransomware attacks are more sophisticated now. It's not just encryption. They're also threatening to shame you by spreading your data, stealing your data, and disclosing it on social media. The ransomware demands are as high as I've seen $50 million. It's incredible just how much money, and it's all in crypto, of course, these ransomware attackers are asking for. The supply chain attacks that 5 or 6 months ago, people weren't talking about supply chains as much as they are now, but it's a huge issue, obviously, right now. The president yesterday issued a 34-page executive order on cyber. We're going to talk about that in a little bit. So there's just a tremendous amount happening, and we have the perfect panel. So let's start. I'm going to ask all three of you each a question right now. First of all, Jack, tell us what the heck is going on. What does everybody need to worry about from your perspective, because you see everything? Second of all, Brent, what is the SEC doing about all of this exactly? And Susan, what do you do to make sure Brent doesn't come knocking on one of your clients' doors? So let's start with Jack, and then we'll move the three of you. We're going to have lots of discussion. I hope we'll get some questions and get to those as well. Just throw them up in the Q&A and I'll look at them. Thanks. Jack.
Thanks, John. And yeah, I'm not sure we have enough time to go over what is happening. Presently, just in the last 24 hours, I think everybody can see the extent and how the landscape continues to change. I think that's the biggest takeaway right now, is that it really is the Wild West out there right now, and having a plan early on, it's not a matter of time before somebody comes knocking on your door and they're in your system and there's a lot of bad guys out there with minimal skills, and as you talked about, subscription services on ransomware. You don't need to be that really sophisticated nation state. You really could just sign up for a subscription and you're in the game. And there are very smart bad guys out there right now that are going after companies that they know are going to pay. And I think that's the biggest thing, is that they're not going to really go after, police departments or even, sometimes city governments, because they don't have the money. But, they're going to go after pharmaceutical and healthcare and financial services, because they're the ones that are really going to be the juicy targets, that they're going to have the wallets and the checkbook that are going to be willing to write that check. So lots of it moves very quickly, and I think a lot of companies are caught flat-footed because they don't think it's going to happen to them. And I'm here to tell you, it is going to happen to you. It's just a matter of time.
Okay, so Brent, do you have the resources to stop all this madness and make us feel a lot safer?
With that segue, let me start with being the first SEC staff member to have the privilege to say that the views I expressed today on this panel are my views and do not necessarily reflect those of the commission, the commissioners, or other members of the staff, which is, a good, I feel like a good answer to your question, John, already. But I thought I'd start with just a little bit of a high level about, about the cyber unit and about the enforcement division's work in this space to date. Let me start off by saying, obviously it's an exciting time of transition with the new chair, and we understand practitioners are anxious to get a sense of the new administration's priorities in many contexts, including in the context of cybersecurity. Cybersecurity threats obviously pose an omnipresent and ever-growing risk across the public and private sector. There's obviously a lot to do for regulators to ensure we're responsive to these risks. We're still in the early days of the new administration, and so we'll have to wait to see Chair Gensler's particular areas of focus in this space. But, as I mentioned in the interim, I thought it would be helpful just to provide some context about the enforcement division's purview with respect to cybersecurity and the function of the division's cyber unit that I'm in fulfilling that role to date. As most of the attendees likely know, the cyber unit is a specialized unit within the Division of Enforcement. We were formed in late 2017, and our unit has a broad mandate for enforcing violations of the federal securities laws for cyber-related issues, including not just cybersecurity, digital assets, cyber-related illegal trading, security law violations involving online misconduct, including the dark web, but obviously cybersecurity, which is the topic today. And historically, there's really been two parts of our cybersecurity program within the unit. For SEC registrants, so here we're thinking of BDs and IAs, the unit has responsibility for investigating violations involving certain controls that registrants are required to have related to cybersecurity and customer data. So, we charge violations of Reg SP, Reg SID, Reg SCI. John, as you mentioned, just yesterday, we filed a settled action against GWFS, which is, it's sort of in this, sort of what we're talking about in this context. It involved the failure to file or failure to adequately file SARs related to attempted account takeovers and retirement accounts. So, again, it's a reflection of sort of our scope with respect to registrants. For public company issuers, the SEC is responsible for investigating both issuer disclosures and internal accounting controls, which hopefully we'll talk about a little bit. And in that context, we brought actions involving the accuracy and timeliness of disclosures and the maintenance of disclosure controls. And then we've also investigated public companies' maintenance of internal accounting controls related to cyber-related threats. But, the bottom line, and I think you and Jack have already sort of flagged this, there's a lot to do in this space, and we in the cyber unit will follow the new chair's lead in focusing our efforts in the areas he deems to be the highest risks and priorities.
Right. Well, I put a link to that case about the SARs in the chat, so anybody can link onto the press release on that. So, Susan, what are you advising? It's kind of an odd time. You have all these terrible things going on. You've got clients who are public issuers, like Brent said, who are worried about their disclosure or their internal accounting, which fall under Brent's jurisdiction. Or you've got these regulated entities. We just got a question about introducing broker-dealers, non-carrying, non-custodian. What's the impact on them? How are you doling out your advice, and what are you telling people when they give you a call, which I'm sure they're doing after yesterday?
So I think first and foremost, and it goes without saying, but I'm going to say it anyway, when you've been attacked, you're the victim. And, often when you're interacting with the SEC, you don't need to say that constantly, but it doesn't hurt to remind. But that's not going to get you over the finish line, and that's not going to make Brent go away. Just saying, I'm the victim of this attack. We tried to do what we could do. We couldn't stop it. But we're the victim isn't going to help. You have to have a plan in place, and that's what Jack said. And when, not only just an incident response plan of how to deal with the problem, but in order that the first thing that's going to happen when there's a breach is you will very likely get a subpoena or a request for information from Brent. And among the things that Brent is going to be asking for, and he touched on this a little bit, are what kind of disclosure controls did you have? What were your internal controls? And did you have an insider trading policy and a plan in place with respect to this breach? So on the disclosure controls, that becomes a real issue, because probably the biggest question that public issuers have is this something that's material? Is this something that I should disclose? Or is it something that we've been able to handle internally and we don't need to disclose it?
Susan, please tell us what your advice is in that. I've been involved in situations where a cybersecurity expert like Jack, says these happen all the time, it's not material, or another cybersecurity person like Jack says these are really critical problems. What do you do? Is it in the K, in the Q? Is it an 8K? And how do you?
It's one of those horrible, it depends kind of answers. And the only way that you can know is to have a fulsome disclosure process in place where you have people keeping apprised of what are the breaches, because chances are your company has been attacked on more than one occasion, numerous occasions, and you have to have some frame of reference as to, okay, this is a little one that we were able to control immediately and stop it, versus something that's much bigger. In 2018, I think everyone knows the SEC did put out some guidance, probably not as much guidance as people would have liked, about what is material. And it really, involves things like what are the effects on the operations, reputational, were the crown jewels of the company stolen with respect to personal identifying information, how does this deal with customer relations, vendor relations, just all sorts of things that go into the mix. And you need to have a system in place that's able to make those kinds of evaluations so that you're not doing it on the fly, because that's the worst thing that can happen is if this is done in a vacuum, it's done on the fly, you have procedures that are very aspirational in place, but you don't abide by them. It becomes very, very difficult, to defend how you handle things at the SEC, because while you're drinking out of the fire hose at that point in time of dealing with the breach and who to disclose and all the various constituencies that you're dealing with, the SEC has the benefit of hindsight, and they're going to look at things with that benefit. So you need to be prepared.
All right. Well, that leads to another question. This goes to Jack and to Brent, and it also comes from one of the audience members. And I'm curious how this factors in. The question is, any thoughts on an independent third-party cyber risk assessment requirement? I know most firms use third parties now, but there are many who do it internally and may be deficient in their plans, risks assessments, testing, and incident responses. Here's my question that sort of tags along with that, Jack and Brent. So if you decide to, does the new 34-page report that I mentioned, which came out yesterday, and I assume, Jack, you've read it and memorized it by now, do you think that will encourage, since that's a very governance-based document, and that's what Susan's talking about, governance, not tool-based, is that going to become more common? And what do you think of that? And then if you're working on one of these, Brent, are you going to ask for that report if it's conducted under the context of attorney-client privilege? How do you manage that issue when you get pushback from defense counsel who don't necessarily want you reading what Jack said, because Jack's report has the good, the bad, and the ugly, and might not be modulated in the way that the attorney wants it to? So that's a long question. I'll leave it to Jack and Brent, and then maybe Susan, you've got some comments.
Yeah, I'll chomp off on it first. You talked about provisioning a third party initially. I think that shows a company that is thoughtful and they are taking necessary precautions. That goes a long way when you're talking to a court that, hey, we just didn't sit on our laurels here. We brought in experts to look at our system, to make recommendations. We've changed certain parts of our network topology based on what people are seeing on here. So we've taken proactive steps to do something. The fact that we were still hit, I think that gives a reasonableness to a judge saying, look, we just didn't, put our head in the sands on this. We are doing everything we can to include bringing in, costly third parties to assess and give us some recommendations on that. I'll turn it over to Brent on that, that third party and that, defense attorney product on that. So I'll let Brent speak to that.
I don't mean to put it on your lap that way, Brent, because I know there's no sort of one size fits all, but I think defense counsel would appreciate just hearing from you what your thoughts are about the communications, the reports, and the other things that go on between Jack and the client post breach, which are done at the direction of counsel.
Yeah, no, I mean, look, it's a great question. I think what I would say is, when you're thinking about, the way the SEC conducts its investigations, it's really hard for me to sit here and give sort of like a one size fits all response to, the types of information that we're going to request, how we're going to navigate specific issues related to attorney-client privilege, even including, if there's, if an attorney has worked with the third party expert in the context of incident response. But, obviously sort of at a high level, right, when SEC is conducting an investigation, we're going to try and get sufficient information for us to understand the nature of any incident and to understand, obviously whether there's any potential securities law violations. And, depending on the context, that can require us to sort of look behind the hood at certain things. But it's really going to depend. One other thing I just thought, if it's all right, John, to just kind of pick up on something that Susan had said, which is, I really think that, I kind of want to echo that. I think the 2018 Commission guidance, really placed a heavy emphasis on the importance of disclosure controls in this context. And so I think, when we're talking about sort of what the company needs to do in the context of a response of an incident, I think that was part of the focus of the 2018 guidance was to really say, this is why we're saying, get disclosure controls in place. It's a requirement under the federal securities laws to establish and maintain appropriate and effective disclosure controls, to make sure that the disclosures are accurate and timely, and also so that there's a process for evaluating materiality. You kind of put it on Susan's lap to say, okay, what are you going to do? Is this material? Is it not? I think what the 2018 guidance really said is have a process for how to evaluate that, because I think the idea is, right, you're not going to be able to kind of develop that whole cloth in the context of an incident response, which we understand can be a very stressful time for an organization.
Absolutely. That leads me to a question for Susan. So Susan, that's just great advice, Brent. Getting the process down, no matter what Susan's answer is, it becomes defensible if you had a process. Again, it goes to governance. So Susan, you hire Jack to help you out for the incident response. He does write a report, or there are all sorts of internal documents that are really important. The SEC examiners come in and want to see those documents. Brent wants to see those documents. You know, in the back of your mind, hey, if I tell Brent no, then he can just subpoena all these IT people and hear from it himself firsthand. You know that if you turn OC down, the examiners, they can somehow impact your licensure. How do you manage that situation with an aggressive OC, an aggressive enforcement division who wants to know what happened, and you might have some very inculpatory or exculpatory evidence in your possession, but it was created under the auspices of privilege?
I mean, I think there's several ways that you can do it. There's certain ways that you can soften the blow with Brent by perhaps giving just a very high level attorney proffer without waiving privilege. I think in the first instance, you really have to evaluate, because there are going to be class action plaintiffs out there. And once I tell Brent what happened, it is very hard then to turn around and argue that it's privileged. And courts, more and more and more are going in the direction of, Jack's report no longer has any protection because I gave it to Brent, or there's even some case law out there that says if I verbally, describe it. So you have to be very, very careful in describing what happened. And I think in some respects, not having a report at all or having a very bare bones report might be the best way to go. There's a pretty scary case actually that came out of the District of DC, not any securities related case, but it's the Wengu Clark Hill case. And I don't know if people are familiar with that case. But in essence, just cutting to the chase of what the court decided, the law firm that hired the expert, said on the front that this report was prepared for a variety of reasons, including for potential litigation purposes or something to that effect. The judge seized on that, just including, and said, hey, this is not work product because it's not prepared for the purpose of, in anticipation of litigation, which, frankly, that's what it turned out to be. But at the end of the day, it was viewed to be for a business purpose. So even fighting the privilege fight is tough. But then also it had been shared with law enforcement. So you really have a very, very fine line dance. And to the extent, Brent will never say waive the privilege. He can't say that. But you will lose cooperation points, in many respects. And if you're trying to demonstrate that you're being a good corporate citizen, there are ways to do it, and perhaps attorney proffer in a very high level. But obviously, the safest is to, have a bare bones report at best. I mean, you obviously want to show that you brought in experts, that you did the right thing, but there's just a lot of landmines, and it's definitely not a one size fits all. But just having a conversation with the staff, explaining some of the vulnerabilities and some of the issues, and trying to come up with some workarounds, even if it is having somebody come in and provide testimony from the IT group.
Well, that sort of turns to another question I have for Jack and for Brent. And law enforcement liaison is something that's always debated in these situations, probably by every single panel, depending on the violation. Mm-hmm. When do you tell the SEC what happened? When do you tell the FBI what happened? I'm curious, Jack and Brent, Jack, when you worked at the FBI, what did you think were the best way that firms handled it? And what are some examples of the worst way firms handle it, other than just they never told you? And Brent, the same question, as far as when did you think the SEC expects to hear about some sort of incident at a regulated entity, not a public company? I'm talking about the regulated entity side. So Jack and Brent, what do you think? Start with Jack.
I can chomp on that a little bit. The best way I've seen is the time to get to know the FBI or Department of Homeland Security or Secret Service is not when you're in the middle of a crisis. That is a terrible time to get to know your local law enforcement on the federal levels. The locals probably aren't going to have a lot of interaction with this because it's just really not in their swim lane. But there are lots of opportunities to have conversations early on for a company to introduce themselves to the law enforcement entities, specifically the FBI's cyber entity. So when they have a problem, they can pick the phone up and they know who they're talking to. It's not in the middle of a crisis. They may have had some interactions over the years with them. It's the ones where all of a sudden they don't know how to talk to us. They don't understand, we're going to be asking for certain documents. We always try to give cover fire where we would have a compelling, subpoena to a company. We're never going to ask for something just, hey, just give it to us and let us take a look at that. There may be some conversations around that on the back end, but when we, everything we take in from a company, if it's going to be going after attribution and a prosecution or a nation state, is going to be something that, we're going to be very tight on what we can use. And we're going to do, the Bureau does a great job in trying to keep companies kind of out of the limelight. You can talk to the FBI and rest assured it is not going to hit the press, until such a time when there's going to be arrests and there's going to be indictments. And then there possibly is going to be something in there that we have to disclose to the court. So I guess the big takeaway here is get to know your local, FBI offices, pick the phone up and ask for, their cyber branch and start having a conversation early on, because in the middle of a crisis is not the time to do it.
Interesting. Brent, what are your thoughts? I know that people aren't going to call it the enforcement division and say, hi there, we just committed an egregious cybersecurity violation and we wanted to let you know. Maybe they will if they're really in trouble. But I'm talking about just SEC notification with respect to financial firms. Obviously, you have an interest in keeping all investors safe, and you have an expectation that financial firms will loop you into when these situations arise. So if there is some bad things going on, you can work with the FBI and whomever else you deem necessary. What are your thoughts on that?
Yeah, no, I mean, it triggers a couple. There's a couple of threads to it that I thought I would be maybe helpful to touch upon. First, when you're talking about, and Jack, I think, has alluded to this in a couple of his answers, this idea of, sort of the existence of multiple regulators in the space. Obviously, as we do in, a lot of other spaces, right? The SEC works collaboratively with other agencies. It's very common for us to conduct investigations, whether we're talking about public companies or registrants, in parallel with other government agencies, both state and federal. The other thing I would say is you have to be mindful of the role of exam in this context, right? So, I'm not going to. I know we have great people from our exam team that will be talking later, so I don't need to go into that too much. But it's definitely worth at least noting that in the context of where we're talking about cybersecurity issues related to registrants, it's very common for exam to, sort of take the lead in conducting any evaluation of a registrant in terms of whether they've complied with their cybersecurity controls. So, again, thinking of Reg SP and Reg SID. And, for anybody who sort of hasn't seen it, OC put out, or formerly known as OC, the Division of Exam, put out, a really helpful set of observations about cybersecurity resiliency in early 2020. It's detailed. I wouldn't do it justice. And again, they'll probably talk about it later. But it gives a lot of, I think, really concrete feedback of sort of the practices that exam saw, and go through a lot of the areas that we've been talking today. So I think that's from kind of what other agencies are doing, what exam is doing. When you're talking about enforcement's role here, I think it's really just important to sort of, again, as I mentioned at the top, I think something that's helpful is just to kind of understand what the purview of the SEC has been with respect to registrants, right? So, it's been a core part of what the cyber unit's mandate has been with respect to cybersecurity since we were formed. And the regulations applicable to BDs and IAs, the central goal there is protecting customer information. So we've investigated registrants to ensure that they comply with regulations that require protection of customer information. And to date, the two core regulations in this regard that I've referenced a couple of times are Reg SP and Reg SID. We've obviously brought a handful of enforcement actions under Reg SP. Exam has done a risk alert about Reg SP. I think we've sort of been active in that space. Reg SID more recently, we brought our first action involving that regulation against Voya Financial. And as we talked about at the top, I think the GWFS matter that came out yesterday, I think sort of fits in all of this, right? Again, registrants sort of having obligations, very specific obligations related to cybersecurity controls, cybersecurity policies, and in that context, AML. That's what we're thinking about. And I think it's obviously there's an expectation that registrants take their obligations with respect to these regulations seriously, and that's part of our purview in the cyber unit to look at those things.
Susan, in light of all that, does it ever make sense during any kind of breach to disclose anything more than we experienced a data security incident, we've engaged an independent cybersecurity firm to investigate, we take cybersecurity seriously, and we will continue to make the best effort possible to keep data safe and secure, even if you've made a ransomware payment? I mean, remember the dirty little secret that most of the time companies are paying the ransomware in crypto. And, I have all sorts of issues with crypto, but if a company wants to make the payment, I don't know that there's any law that says they can't make the payment. So you're caught with a client who maybe made this payment, doesn't know exactly what happened, is still trying to figure that out. On Monday, they thought it was Omega. On Friday, they thought it was Alpha. And on next Wednesday, they thought it was Delta. So things were just constantly changing. Does it ever make sense to have any other disclosure than that? And how do you wrestle with that? And I mean public disclosure, and I also mean notifying your regulators.
I think that, if you're going to make a disclosure, it needs to be meaningful to the public. And just saying, we experienced a data breach and an incident, we're trying to take care of it, frankly, doesn't do anything except cause more problems with investors, because investors are going to be saying, what is this? Is this SolarWinds? I mean, what happened here? So you have to at least provide enough detail as to, to the extent how it occurred, when it occurred, who was affected, and what you're doing. Similar to the kind of disclosure that you're required to make by certain states, but there's no requirement that you immediately pick up the phone and call the SEC or put out an 8K if you've had a breach, because you first of all need to do a materiality assessment, and it may not be material. But if you decide it is material and you decide to talk, it does need to be meaningful, because you're not doing yourself a favor. You're not doing your investors a favor. You're frankly going to cause more questions from the SEC if you put out something that's that bare bones that doesn't really say anything, but causes more panic, quite frankly.
Interesting. Great advice. Jack, with respect to these ransomware attacks, what happens? For me, I often get these calls on Sundays, and they're the oddest calls because the victim is so panicked that they're literally doing Google searches, help me on ransomware. And for whatever reason, my name often comes up. I find it to be almost like an emergency room situation. How do you handle that? And Susan mentioned that there are state regulators, there are federal regulators. I'm not asking you for the legal analysis of that. Susan can give us some of that. But how are you handling these crazy calls that come in? And everybody, it's very different than a financial problem, because companies have experienced financial problems before, or financial related crisis. Generally in the cyber area, they've never experienced anything like this. And when you say to them, yeah, most victims pay, their jaws drop. But then their next question is, well, how much should we pay and how do we do it? And remember all the OFAC issues that can come into play because you may be paying a terrorist. So
Yeah.
take us through some of that. We don't have a lot of time left, but
No. And I'll make it brief. A lot of the recommendations that we will give with counsel and the company as well is based on the forensic findings. So, what software is impacted, what data has it been exfiltrated? Is it locked up? Are there backups? Is it truly, did they get what they say they really got? In some cases, we can tell a client that this never got exfiltrated. They don't have what they're telling you. Don't pay the ransom on this. You can restore from backups. You're good to go. Other times we'll tell a client, yeah, your crown jewels are sitting on, some server in Russia right now, and they're asking for a $4 million payment. We will bring in a specialized firm to help with those negotiations. Generally, it gets knocked down to about 10% to what they were asking, but they're, now you pay with the assurances from the bad guys saying that, yeah, if you pay us, we're not going to release this, or we'll give you the keys back. And that's always the hard point with a company is like, if I pay this, am I really going to get the keys back? You're dealing with a criminal and who's already, demonstrated pretty bad behavior. So we can't tell you that it is. Now, I think we're starting to see some data where in over 90%, they will do what they say, because this is a business model to them. And quite honestly, I've read some communications between bad guys and companies where they will say, hey, this is a business for us. And if we aren't true to our word, people aren't going to trust us. It's amazing email to read sometimes, but it really depends on forensic findings, what we will recommend with counsel, and what will be in this trilateral conversation. But ultimately, it's the clients and the counsel's decision to make.
Interesting. Susan, I read recently, a client pointed out to me that France has told insurance companies something along the lines of they can't pay ransomware anymore. So this debate is raging, whether this is a moral hazard that the insurance companies have created. And this debate comes up all the time. On the one hand, yeah, maybe we should tell insurance companies not to pay these attackers so they won't attack. But on the other hand, okay, fine, we tell them not to pay, and then the pipeline is out for however many weeks, and none of us can drive to work, and the whole economy crashes. So I'm not asking you for the solution on that, but I am curious about two things about that. Number one, in working with insurance companies, what do you think are the best practices along these lines, and how, because that has changed dramatically? And also the cybersecurity guidance that Brent mentioned, that you mentioned, that came from OC for regulated entities, talks about vendor due diligence. And essentially that's supply chain due diligence, vendor due diligence. And to me, it's good-hearted advice that, hey, you need to find out if your vendors have good cyber. But if my cloud provider is AWS, what am I supposed to do? Give them a 100-page survey and tell them to fill it out for me? They're not going to. So I think it's your vendor due diligence. You're handcuffed a lot of the time because your vendor's just not going to give you the kind of information you need. So again, in just the short few minutes that we have left, what are your thoughts on those issues?
I think on insurance, you do need to have conversations with your broker on this. There are a number, and you should have cyber insurance, and it has evolved, certainly. And that is something that you absolutely should look to, and talking with your broker about what best fits your business. There isn't really a one size fits all. But yeah, the ransom payment is, that's a really hot issue right now. And I think it's something that, you should definitely speak with your broker about on that. As to vendor due diligence, this is so hard, because if your vendor gets attacked, not only, you're a victim almost multiplied hundreds and hundreds of times beyond that, because you don't have any control over it, over what's being done to address the issue. But the SEC certainly expects that you have done some due diligence. And I think, all you can do, to the extent that you are engaging with a established entity as opposed to some sort of fly-by-night company, not that anybody would, But you have to at least make an effort to do some diligence. And if it's, sending a questionnaire, it doesn't have to be 100 pages, but at least some follow-up efforts, both in, assessing that this is a vendor that you need to have versus, do I need to continue to do annual 100-page surveys? Probably not for AWS. But there might be some others, and it really depends on the type of information that they're hosting. If they're hosting, your crown jewels and some of the most, personal information, the SEC is going to expect that you've taken efforts to conduct due diligence to make sure that this vendor is protecting it, because the SEC does bring cases, and they have brought cases, at least one case, as a result of, a vendor breach.
This is a great time to turn to Brent. I'd really be interested in your opinion. What are the red flags, if that's a fair question, Brent, in terms of when something comes across your desk and you see a vendor-related data security incident and you think, well, the guidance has said that they're supposed to do due diligence. What do you think about those issues?
Yeah. So, a couple of things with respect to vendors that come to mind. First, again, I really think sort of our 2020 or exams 2020 guidance here had some really sort of tangible observations about vendor management. A couple of things that they talked about in the exam observations: establishing a vendor management program, understanding vendor relationships, vendor monitoring and testing. And the other thing I wanted to, when you're talking about enforcement in this space, the other thing I just wanted to highlight, right, where another place where we talked about vendors in the context of public companies is the 2018 investigative report that the Division of Enforcement issued regarding. It was in the context of business email compromises. Right. And, the focus there was on internal accounting controls. So we've talked about that. And it was an investigation of public companies that fell victim to business email compromises. But one of the types of business email compromise that was described in that report had to do with cyber-related fraud involving the electronic communications of people impersonating the issuer's vendors. So, I think that report sort of gave a tangible example of where, of the vendors, of the relationship of a public company and its vendors, and sort of how that can implicate a public company's obligations under 13B2B regarding internal accounting controls. So, there's obviously a few spaces where, we've been involved with respect to vendors.
A lot of people miss that, don't they, Brett? I don't want you to have to agree with me on that, but I think a lot of people miss that the SEC's guidance relates to this internal accounting control notion, because if you have bad cybersecurity, you can't have good accounting, because your accounting is going to be wrong because it's not taking into account all your cybersecurity weaknesses. Is that right, Susan?
I think that's right. And also part of the internal controls is protecting assets. It's not just having, controls to protect the integrity of your financial reporting. It's also protecting your assets. And I think that's how, at least in advising clients, that certainly is also a very, very significant piece of, why you have to have a robust control system. And the control system can be as simple as training, just training people not to click that weird email that's, Amazon.net as opposed to Amazon.com, which could trigger all sorts of bad things.
That's a tough one, probably even for someone like Jack, who works 23 hours a day. That 1 hour, the 1 hour of sleep is not enough, Jack. Jack, we have 1 minute left for you to tell the world, before Bruce says goodbye, just 1 minute left to say, what's your number one piece of advice for your clients? Given all your experience at the FBI and everywhere.
Have a plan. It's that simple. What are you going to do? It could be a very simple plan, but have a plan. Who are you going to call? Have a relationship with people before you need them.
What about tabletops too? You do those occasionally?
Yeah, Kroll and other cybersecurity, we do tabletops, and we'll do in what we call injections into that. Hey, this is what we're seeing, and we try and make it very, very timely and very relevant. So
Do you
have
have
a
to
plan.
bring a working FBI agent into your tabletops, like someone from the FBI is currently working there, or no?
Yeah, we do actually, and not only that, we bring U.S. attorneys in too for a prosecution standpoint to kind of make it interesting. So they're a lot of fun.
For your next tabletop, I want you to bring Brent in. I can tell how much he would really like to participate.
I'm sure Brent has enough on his plate right now.
Bruce, I see your smiling face there. I guess we're finished. I have really enjoyed this panel. I think we covered more topics than I thought we were going to be able to cover. I hope everybody will enjoy the rest of the conference because we have lots of other experts coming in. And Bruce, any final thoughts? And I want to thank Susan, Brent, and Jack on the West Coast. I'm on the East Coast for coming, especially Brent, because to have someone from the SEC be willing to stand here and speak to everyone is really just extraordinary. It says a lot about the SEC that I'm always very proud of, having worked there, that they're willing to go out and take questions and participate and be visible and be transparent. So thanks especially to Brent and of course to Susan and Jack.
Agree 100%. And thank you, John, for moderating so well and getting the panel off and the whole conference off to a great start.